This is Liberty Under Attack Radio, hosted by Shane and Matt. Your place for documented truth and where freedom is the only agenda. We must end the terror war.
And good evening and welcome to Liberty Under Attack Radio on the ʻfālaNGks Radio Network. As always, I'm your host Shane. My co-host Matt had previous arrangements tonight, so you are stuck with me. Tonight we are joined by Kyle Rearden from the Last Bastille blog. You can join in the discussion by calling 567-314-9296 or on Skype at FPRN Radio Live. I do know that Kyle has a lot to get through tonight, but if you have any thoughts or input on the subject at hand, please call in and join us. If you're away from your computer, you can listen on your mobile device by using the Listen Live line provided by Audio Now. That number is 712-432-4365. And lastly, you can also tune into all of your favorite FPRN shows on apps like TuneIn Radio, Shoutcast, and Stitcher. So Matt's weekly edition of the Terror Industrial Complex and You will be up on the website, libertyunderattack.com, right after the show. He's also looking for your questions on the Terror Industrial Complex. So if you have any questions, please email them to matt@libertyunderattack.com. This week I was working on some future plans for Liberty Under Attack. One of those things that has been a project for a while is a complete redesign of the website. Fortunately, there are plans in place, and I have the proper assistance to get this done. It's going to be a lot better of a website, a lot more easy to maneuver. And that should be completed and live in August sometime, so definitely keep a lookout for that. So, as I mentioned, this evening we are joined by Kyle Rearden. Kyle is a contributor to the Last Bastille blog and used to have a relatively large YouTube channel. He covers a wide variety of topics in his writings, and the one at hand this evening is the history of Dragnet Wiretapping and possible solutions. Kyle and I have only spoken a few times, but I know our listeners are going to benefit from him coming on Liberty Under Attack Radio. So Kyle, welcome to the show, brother. Definitely excited to have you on. How are you doing this evening?
I'm doing quite well, Shane. It's good to be on with you, too.
Awesome, man. Awesome. So, Kyle, why don't you tell the listeners a little about yourself, what your main interests are, and also where they can find your work.
Sure. I have a lot of different hats, as it were, but I guess for purposes of tonight, I'm primarily a blogger, and I look at various different political matters, everything ranging from the current American police state to central banking to the foreign wars of aggression, and many, many other things. My blog is located at the Last Bastille. Bastille is spelled B-A-S-T-I-L-L-E, thelastbastille.wordpress.com.
Okay, awesome. Awesome. So the subject tonight is the history of Dragnet Wiretapping and solutions. So Kyle, why don't you kind of lay out the history of Dragnet Wiretapping? Where are we going to begin?
I think probably, Shane, the best place to begin is with an assumption that at least this government, if not many other governments, like to imply. And what that is their assertion that they have a so-called right to know about the intimate details of an entire citizenry. Now, this is very interesting because what they fail to realize is that governments do not have rights. This is very important, only people, individuals, have rights. Governments do not have rights. So when they assert, we have a right to know about the intimate details of your life and also that of everyone else, just because we said so, right off the bat, they're completely, incorrect, I guess is the polite way to put it.
Mm-hmm.
So when you combine this with so, as you can see, this problem of their claim of right to know directly contradicts their other claim of what is usually referred to as the state secrets privilege. And many people have mentioned this, including Ed Snowden. So as you can see, they claim that we must know about everyone else and their lives. But then we get to have all the secrets about our activities and so forth, and we don't want to have any transparency because of these alleged claims, whether it's national security or any of this other hyperbole that really, quite honestly, doesn't make sense to anybody who got a decent education in much of anything.
Mm-hmm.
So the hypocrisy really is regarding transparency, and what it really is evocative of what I've mentioned earlier in other interviews I've had. This idea of the panopticon, which of course the original meaning of that word is a type of prison architecture whereby there's a central guard unit and all the prison cells form a circle around this guard tower where their prisoners have no privacy. And of course, this is very different from the traditional prison architecture, which is more rectangular in its design, and therefore the prisoners could arguably, shift their bodies or their beds in a way to have a modicum of privacy, as opposed to a panopticon, which doesn't. So right off the bat, there is there's very much a problem with the government's insistence on right to know, as that contradicts their so-called state secrets privilege.
Yep, indeed. So I know there were a lot of I guess incremental implementations of this Dragnet wiretapping. I guess you'd call it nightmare that we're living under today. Where's a good place to begin as far as I guess you call it legislation or political actions? I guess where would be a good place to start for that?
I think the important place to start, Shane, is the government's insistence on their so-called right to know starting to occur even before there were such a thing as telephones, and it shows the gradual evolution, if you will, of the government just grabbing more and more power unto itself. For example, you can look at the interception of mail, which is, of course, what the founders were very much against, especially when you consider that the British Crown at that time, the colonial American period, there was apparently a mandate that sanctioned the government's ability to intercept all mail within the British Empire. But you can also see this happening in other places. For instance, in post-revolutionary France, Joseph Fouché intercepted the mails for Napoleon Bonaparte, and José Rodriguez de Francia intercepted Paraguayan mail throughout the early 19th century. So that's the predecessor. But then once you had the invention of the telephone, thereabouts in about 1876 or so, it provided yet another way for governments to commit what is little else than, I would assume, would be espionage against their own citizens. For instance, probably the best example of this was Nicolae Ceausescu's Romanian Securitate, where they combined the techniques of intercepting both mail and telephone communications in Romania. So that's the lead up. It wasn't so much the telephones; it was starting with the mails, and then different governments just then transitioned to the telephone, because of course the government doesn't like having its powers limited. It constantly wants to expand and grow, and you can see the same thing here. Mm-hmm. But I think at this point, it's really important to take a step back for a moment, and before we look at the government's own actions, I think was how you put it, I think it's important to understand first the technological foundation for telephones, because if we don't cover this first, a lot of the other stuff with regarding the government's actions is not going to make too much sense. Mm-hmm. So unlike a technology like a sealed envelope, a paper envelope, the science of the telephone itself does not value individual privacy. What I mean by that is that telephones were originally designed to overcome a human limitation, namely the need to be in the same physical space before talking to someone else during the same moment of time. Now, obviously, this could be exploited, and unfortunately, there is also a confusion between eavesdropping versus wiretapping. Eavesdropping is broader. That would be things like, even before the invention of the telephone, putting your ear against a door to try and listen to what the voices on the other side of the door or even a wall are saying. Whereas wiretapping is more specifically intercepting the communications on, let's say, like an actual telephone line, hence the name wiretapping. Tapping into the wire, the telephone wire, is what that really means. Mm-hmm. So simply put, we could define wiretapping as the specific action of intercepting telephonic communications. And this can be done either through hard wiretaps, putting a transmitting bug within a wall socket, putting said bug in a telephone handset, or even putting some sort of interception device on a nearby telephone pole's utility junction box, futzing around with a telephone switching station, or even interception by other means, such as snatching radio waves out of the air. My point here, Shane, is that whether it be by landline, cordless, cellular, satellite, ham radio, or even voice over internet protocol, VoIP, modern telephony is considered private only to the extent that there is a cultural expectation that it should be so, but not so with regard to the nature of the technology itself. So this brief outline of the science of wiretapping is that it is foolish. I think the lesson to be learned here is that it is foolish to project one's false sense of security by crying foul after the fact. Now, don't get me wrong. We do need to have technological countermeasures to be put in place because privacy is important. But before we look at anything else, let's just be honest about what the technology is. The technology itself is not designed to be private. It is designed to satisfy, it's designed to solve a problem. It's for purposes of expediency. So I can talk to you and you to me in the same moment of time without us being physically close to each other like we would in what would now be referred to as like a face-to-face meeting. That is it, not anything more than that. So people's desire for privacy, that's A-okay, but it's a cultural expectation. And what I'm saying tonight is that we need to have a technological solution to making that a reality, which I believe we'll cover a little bit later.
Okay. Yep, we're definitely going to cover some solutions here as well. So what's the next step? Where do you want to go now with this, Kyle?
I think we really need to look at the villain, or at least the main villain, as opposed to the other lackeys who are infamous in their own right. And I think probably regarding this history of Dragnet wiretapping is we need to look at the National Security Agency, the NSA. President Harry Truman unilaterally created the National Security Agency in 1952 specifically for the reason of preventing another Pearl Harbor surprise attack by way of using signals intelligence, abbreviated as SIG-INT. Yet, in 1976, the Church Committee hearings revealed that the NSA had exceeded its foreign intelligence surveillance mandate by monitoring the communications of American citizens whom it deemed were engaging in activities that threatened this so-called fanciful notion of national security. The committee summarized the problems. Their summarization included the finding that, quote, and this is very important, so please pay attention, quote, government officials, including those whose principal duty it is to enforce the law, have violated or ignored the law over long periods of time and have advocated and defended their right to break the law, close quote. So ironically, if you consider this was in 1976, these illegal abuses by NSA at that time were occurring alongside Ceausescu Securitate similarly tapping Romanian telephones. So despite another 25 years to get its act together, NSA not only failed to prevent the 9/11 attacks, but its own internal security was discovered to have been breached a week after the attacks. So without missing a beat, the NSA and the rest of the rather lackadaisical United States intelligence community, so-called, they lobbied Congress to grant them more power as a reward for their infamous failures. And all in the name of national security for this brand new so-called war on terror, whom Brigadier General, now Lieutenant General, Mark Schlesinger, said will go on for another 50 to 100 years.
Not meant to end.
Right. It's not meant to end. That's kind of the whole point. So, having said that, let's go ahead and I think it would probably be a good time to jump into the legality of wiretapping because, unfortunately, a lot of people misunderstand this. So, as many of your listeners, I'm sure, are pretty savvy, if we're going to look at the law, or what seems to pass for the law these days, because that's kind of a heady subject by itself, is let's start with let's see, National Security Agency technically falls under the federal government, so we should probably use the United States Constitution of 1787. So constitutionally, the Fourth Amendment's search and seizure clause says, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, close quote. Notice it didn't say a lot of other things it could have said. I mean, what part of shall not be violated do you not understand? You know, kind of a lot like, you know, shall not be infringed, wink, wink, nudge, nudge. I mean, it says shall not. That's what the amendment says. So I don't know. I mean, some people have trouble making sense of that.
Basic English, yeah.
Yeah. Or even like the former head of NSA, Michael Hayden. There's an infamous clip on YouTube your listeners may be interested in trying to look at some point that I just remembered, where he was quibbling with a reporter years ago about what the Fourth Amendment actually means. And so, wow, okay. So, for the sake of political expediency in the wake of 9/11, former President George W. Bush's White House asserted that pursuant to the Article 2, Section 2, Clause 1 delegated power as the Commander-in-Chief of the Army and the Navy of the United States and of the militia of the several states, the executive office of the President enjoyed the implied power to wiretap anyone merely suspected of threatening so-called national security. That was kind of their official story, and so this is rather problematic, despite the fact that the Congress has not declared war since World War II, since such declaration is required pursuant to Article 1, Section 8. And if you think about it, too, the executive branch here unilaterally assumed a wartime authority to run roughshod over the Fourth Amendment. So to put it a little bit more simply, they're using Article 2, Section 2, Clause 1 to violate the Fourth Amendment. And I guess you could probably work a 10th. I guess you could also probably work a 10th Amendment argument in there as well if you really need to. But you don't even need to go that far with the 10th. They're using Article 2 to violate the 4th. So make sense of that as you will. That's quite literally what happened. Now, I guess the next phase of this mess is to look at the law statutorily. So the Foreign Intelligence Surveillance Act, FISA, of 1978 was passed by the Congress into law as the intended political reform. Keep this in mind. It'll be important in a moment. As the intended political reform in the aftermath of the earlier Churches Committee discovery about the NSA's Project Minaret. That was the domestic spying of American citizens here. The quote I read a moment ago about the government's right to break the law, supposedly, that was the Church Committee. And that was about Project Minaret. So FISA, the reform, created something called the Foreign Intelligence Surveillance Court. This is FISC, F-I-S-C, FISC, whose duty it was to determine whether secretive warrants should be issued against suspected foreign spies. And then, of course, there's the Communications Assistance for Law Enforcement Act, CALEA. That acronym is C-A-L-E-A, CALEA, of 1994, mandated that the telecommunications providers give law enforcement agencies back doors for the purpose of easier wiretapping. And eventually this was expanded to VoIP calls in 2005. So they waited about 11 years, and then they went after VoIP. And then, of course, there's the oh-so-infamous, and here's the full name, the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism, USA Patriot Act of 2001, expanded the FISC's secret warrants to permit so-called roving wiretaps, which lack the specificity required by the Fourth Amendment, and therefore increased the likelihood of what the government has also referred to as incidental intercepts, which is I guess their kind of lazy term for accidental wiretapping is what they mean by incidental intercepts. So to kind of round out the statutory mess, and what really makes this ironic, Shane, is that the FISA Amendments Act of 2008 was passed by the Congress into law as the political reform, kind of like the original FISA was. Mm-hmm. So FISA Amendments Act of 2008 was passed into law as the political reform intended to address the abuses caused by the NSA's Stellar Wind surveillance program, which has also been referred to as the president's surveillance program or terrorist surveillance program. It went under different names, but I believe the official one was Stellar Wind. thereby repeating what had been done exactly 3 decades previously. So, for those of your listeners who may be scratching their heads as to why I don't particularly like reformism, well, this is a solid case study just on this one aspect of Dragnet Wiretapping where it completely, let's see, okay, so we had a problem, in the in the 60s and 70s, and then the NSA got caught. Then there was the legislation, which then created this other surveillance court thing. Then there was more legislation. Then there was Stellar Win. Then we had FISA Amendments Act, which was the second reform, which still hasn't solved the problem. So the reform to reform the previous reform didn't work is pretty much the takeaway here.
Yeah, there's definitely no accountability there either. Definitely none whatsoever. And whenever they were caught red-handed violating our civil liberties, they got more money and got more power, and it's the complete opposite of what should happen.
Mm-hmm. And then of course, the Congress critters, they say, well, we'll pass another law, another reformist measure to reform the previous reform of the other reform. You can kind of see where this really becomes ridiculous. And that's the polite way of putting it, by the way. But that's what happened. So they just repeated the same thing that had been done 3 decades previously. Now let's look at another, shall we say, another aspect of the law, and kind of hop skip a little bit to another branch of the government, which, of course, is the judicial one. So judicially, the 1928 Olmstead versus United States case ruled that the Fourth Amendment search and seizure clause did not apply to the use of wiretaps by federal agents, even if in violation of state law. Yet almost 40 years later, Katz versus United States ruled that the search and seizure clause does protect individuals using a telephone booth from warrantless eavesdropping. Yeah, this gets a little problematic too, because I remember the judge writing in that case mentioned something about how the claim was that the Fourth Amendment protects persons, not places, which, if you think about it, actually directly contradicts the Fourth Amendment that I just read earlier, where it said the right of the people to be secure in their persons, houses, papers, and effects. Now, let me look at something. The right of the people to be secure in their ... houses ... against unreasonable searches and seizures. So why the judge in the Katz case would say that their ruling was Fourth Amendment protects persons, not places, directly contradicts the right of people to be secure in their houses. I mean, a house is a place, right? I would assume so.
Yeah, I would think so. Who knows what they define it as, though?
Well, but that's the federal government for you.
Mm-hmm.
So in his dissenting opinion in the earlier Olmstead case, Judge Louis Brandeis wrote, quote, "Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are the commands to the citizen." Oh, as a side note, compare that to what the Church Committee said earlier about the government's right to break the law. Back to Judge Brandeis. "In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy." Oh, anyway. "To declare that in the administration of the criminal law, the end justifies the means." Now, here's the important part, so listen up. "To declare that the government may commit crimes in order to secure the conviction of a private criminal would bring terrible retribution. So against that pernicious doctrine, this court should resolutely set its face," close quote. Okay, so we have the Church Committee telling us about the government's right to break the law. We have Judge Brandeis in the Olmstead case, dissenting opinion, saying about how there's going to be terrible retribution if the government becomes a lawbreaker. I think there were warning signs, don't you?
I would think so. I would think so.
Oh, but this is not the end of it, not by a long shot. So similarly, Judge William Douglas's concurring opinion in the 1972 United States versus U.S. District Court, this is also referred to as the Keith case, said, quote, "That domestic security is said to be involved here does not draw this case outside the mainstream of Fourth Amendment law. Rather, the recurring desire of reigning officials to employ dragnet techniques to intimidate their critics lies at the core of that prohibition. For it was such excesses as the use of general warrants and the writs of assistance that led to the ratification of the Fourth Amendment, close quote. Okay, so as you could probably tell here, Shane, the federal judiciary's attitude towards wiretapping, at least before 9/11, wasn't so much about the reasonableness of the search and or seizure in question as it was about the Fourth Amendment's Warrant Clause, which says, quote, so this is the second half of the Fourth Amendment, quote, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized, close quote. So in other words, I think it would probably be a good assumption anyway to assume that the very lack of specificity is unreasonable, exceptions to the Warrant Clause notwithstanding. Now, what I can surmise from this, and take it for a grain of salt, but having studied these things, what it seems to me is that the Supreme Court judges did not want to be perceived as hypocrites. So they devised an interpretive scheme whereby as long as warrants do not emulate a writ of assistance, like mentioned in the Keith case, then it would be appropriate for the court to try and rationalize the demands of the executive branch against the individual privacy of the average American citizen. Now, yeah, that's an important one to keep in mind. So the Warrant Clause, but of course they, as you'll see in a little bit, they're going to violate that too. So although this, it's a recurring theme. Imagine that, government breaking the law. They break the law in order to allegedly enforce it. Geez, that sounds like the thesis of a different book, but anyway. Now, although this was the United States Supreme Court's rather moderate position before 9/11, the federal district and appellate judiciary's attitude after 9/11 seems, well, rather imposing, authoritarian possibly. So Judge Lewis Kaplan's 2006 memorandum opinion in United States versus Tamaro et al. For the United States District Court for the Southern District of New York ruled that the FBI's installation of roving wiretap bugs in the defendant's cell phones were not unconstitutional. And about a year later, in 2007 or so, Judge Alice Bachchelder wrote that the United States Court of Appeals for the Sixth Circuit's decision in ACLU versus NSA, where the plaintiffs lacked standing to challenge the NSA Stellar Wind surveillance program, that's Bush Jr.'s one, because they couldn't prove that they were directly targeted by it. So they lost. Consider that for a moment.
Yeah, that's it. That's something.
A few other court cases I do want to mention in passing before we move on to the really scary stuff, as if this wasn't bad enough. So the 2011 Hepting versus AT&T Corporation ruling, which was written by Judge M. Margaret McCowan on the United States Court of Appeals for the Ninth Circuit, found that legal immunity against being sued for the telecommunications companies under Section 802 of FISA, remember that was the reform legislation, right? And this is cross-listed under, and I would suggest your listeners double-check this, of course, as with all the other claims I'm making. This particular section is cross-listed under Title 50, United States Code Section 1885A. 1885A. 50 U.S.C. Section 1885A. And Judge McCowan said that, the legal immunity against the telecommunications companies was constitutional, so you can't sue them, basically. Of course, it's oh so convenient. Several months late, I'm sorry?
Oh, go ahead.
So several months later in 2012, Judge Raymond Fisher conveyed the appellate Ninth Circuit's ruling in United States versus Olivia that the electronic surveillance orders only authorized so-called standard interception techniques and therefore did not convert the defendant's cellular phone into a roving wiretap bug, despite the fact that the police turned the phone into a roving wiretap.
That's ludicrous. That is ludicrous. But we are coming up to a break. So when we come back, we will get more into some modern examples, and then we will talk about some solutions. So stay tuned. We'll be back with more Liberty Under Attack Radio right after this short break.
Scraping your guts, keep your face in the clouds instead of facing the mud. Staying grounded to the earth until your face is in blood.